Hi everyone. Thank you for joining us for day 2 of the two-part series on the impact of the new criminal laws on child rights that is being held by Enfold Proactive Health Trust in collaboration with Project 39A. We have with us Monica Sakhrani and Medha Deo from Project 39A. Monica is the program advisor at the Fair Trial Fellowship, and Medha is the program director of the Fair Trial Fellowship at Project 39A. The second session today will cover the implications of the changes in the new criminal laws, the rights of the accused and children in conflict with the law. While we know that the JJ Act is the overriding law concerning children in conflict with the law, it would be important to understand the implications of these provisions of the new criminal law in the context of CICL between the ages of 16 and 18 years accused of a heinous crime who may be tried as adults, and also with respect to the age of criminal responsibility. Before we begin, I want to mention that this session is being recorded and we request everyone to put themselves on mute while the speakers are presenting. We will have time for questions at the end of Monica and Medha's presentation. So if you have any questions, we request you to hold on to them till the end of the presentations. Over to you, Monica and Medha.
Thank you. Medha will begin, and then as yesterday, I'll follow. Yeah.
Good afternoon. I'm hoping some of you were there yesterday, and this is in a lot of ways continuation of what we did yesterday. So today I'll be again looking at provisions of the Bharatiya Nyaya Sanhita, which were not covered yesterday, and these are mostly the newly introduced offenses and their punishments, which are likely to have implications in which children in conflict with law will be charged, what will be the punishments. So we'll be looking at that. And along with that, I will also be touching upon the one major change that has come in the Indian Evidence Act through the Bharatiya Sakshya Adhiniyam, which is about the admissibility of electronic records. Just one moment, I'll start with my presentation. So starting with the offenses that have been newly brought in, I was also trying to look at the NCRB records to see what are the major offenses under which children in conflict with law are charged. And it indicates that, as a bucket, it's offenses against property, which form the highest percentage altogether, combining theft, robbery, and other offenses against property, which form a very big chunk of, or actually the largest chunk of cases by themselves in terms of where juvenile cases are charged. So in that sense, it's interesting that there is a new offense of snatching which has been introduced. And the act, it's under section 304 of the BNNS. No similar section found place in the IPC, and this act defines it as it is theft if, in order to commit such theft, the offender suddenly or quickly forcibly seizes or grabs or takes away from the person any movable property. So although we work mostly with adult clients in the Fair Trial Fellowship, but we know that a lot of clients who come to us who are charged with cases of either mobile snatching or chain snatching are actually charged with the offense of robbery, which, if compared to the way the offense of snatching plays out now, has much higher punishment. If one were to look at the notes of the act also, the legislative intent behind introducing this provision was to clear the confusion between whether snatching falls under theft or falls under robbery. So from our experience in Maharashtra, we know that these cases are mostly charged under the robbery, which is a higher punishable offense. I don't know if in other states the practice would be to charge with theft. So
you are right. In Karnataka also, it's robbery. It is
robbery, yes. So the benefit here would be that the offense of snatching is punishable up to 3 years with fine, whereas robbery was punishable up to 10 years with fine, and it was extendable up to 14 years if the robbery was done between sunrise and sunset, or even this is under the current act. However, the difference between theft and snatching is that theft, while the punishment remains similar, whereas theft has an or for fine. So if person is charged with theft, they could also be in situations where the judge feels let away on fine. Snatching will not give that kind of a leeway. There is mandatory imprisonment. Also, theft by itself, if there are no additional sections with it, it is a compoundable offense, while snatching is non-compoundable. The next big category, so I touched upon this yesterday, but the next big category of offenses that have been introduced is mob lynching. And this finds place under section 103(2), which is the section relating to murder, and 117(4), which is relating to grievous hurt. So interestingly, the section does not create a special offense, but it just creates special categories of punishment within the offense of murder and grievous hurt. The definition under section 103(2) as well as 117(4) says when a group of 5 or more persons who are motivated by social profile of the victim. Hello? Yeah. So who are motivated by the social profile of the victim, which is their race, caste, or community, sex, place of birth, language, personal belief, and any other ground. If they have caused either murder or grievous hurt, which is as it is understood in the original definition of the section, then there are special categories of punishment, which I'll come to. But the interesting part is that before this act came into place, the Supreme Court and even other civil society organizations had been talking about the increased instances of mob lynching and how there needs to be specialized investigative agencies, specialized mechanisms of how cases of mob lynching are treated. And most mob lynching cases were based on the grounds of religion, but the act itself has not used the term religion as one of the social indicators, which is strange because there are other sections in the act which use the word religion. So it's not as if the act itself does not use the word religion, but both sections which are relating to mob lynching of murder and grievous hurt do not mention the term religion at all. Also, very interestingly, while there is definition of a special punishment, across the 3 acts, there has been no procedure for specialized investigation or collection of evidence or victim protection for victims of mob lynching that have come in. So those provisions remain the general provisions. Also, any other ground in the section creates ambiguity, and there has been no qualifier for what it can mean, which obviously creates that scope of the section being misused in cases where the implementing authorities want it. One difference between the section on murder and the section on grievous hurt is that section on murder includes within this group of 5 or more persons, if any of them have not actually committed the act of murder, but were also acting in concert, they would be covered under the scope of 103(2). Whereas for the case of grievous hurt, the words acting in concert have been missing, which means that to be charged with grievous hurt, common intent, or being part of the group shall not suffice. The person who is being charged with this provision, they need to be actually having committed it has to be proved that they've actually committed the act of grievous hurt. The other interesting part is there is no difference in punishment of grievous hurt and grievous hurt due to mob lynching. So it just remains the same. The next category of offenses is causing death by negligence. So within death by negligence, the first part, which is as it is coming from the old IPC, there's just been enhancement of the maximum punishment from section 304A of IPC, which was earlier the punishment was 2 years, and now it has become to 7 years with fine. This is just the maximum, not the mandatory minimum punishment. There's also been introduction of a new subsection, which is 106(2), which talks about negligence due to, which talks about negligence due to rash driving, and where the person who is accused of rash driving escapes from the scene of the incident or fails to report the incident to a police officer or magistrate soon after the incident. So maximum punishment for this is 10 years with fine. However, this is currently the only section which has not been notified to be applicable from July 1st. So section 106(2) will not yet come into force on July 1st. The trouble with this section also is that requiring an accused to mandatory reporting for reporting an incident which they are probably accused of might be in violation of their right to stand a witness against themselves. Another category of offenses. So we looked at organized crime yesterday. There is a similar section for petty crimes, which does not deal with crimes which are socio-economic in nature or very heinous, like the offenses under organized crime. What this talks about is act of theft, snatching, cheating, unauthorized selling of tickets, betting, gambling, selling of public examination, or any other similar criminal act. Which is committed by a member of an organized group, either singly or jointly. And here the definition is theft includes trick theft, theft from vehicles. So the instances of what can include theft have been made more contemporary, more recent. Nature of offenses have been defined: theft of ATM machines, theft through card skimming, shoplifting. All these new offenses, new instances of offenses have been brought in the explanation. The mandatory minimum punishment of 1 year, and it is extendable up to 7 years with fine. This can again be a section which is very frequently invoked, especially when one looks at the pattern of criminalization of children or even young adults, which is mostly a combination of some sort of neglect, drug use, and petty offenses. But the saving grace in this section, unlike the organized crime or even the terrorist organization section, is that there is no punishment for being a part of the gang per se, or being associated with members of the gang per se, but is more in the nature of when the person is actually involved in committing such a crime. There will also be, so in addition, when this section has to be invoked, it will usually be, my understanding is it will usually be invoked along with the section of the original offense. So let's say if there is a theft, so this section 112 will be applied in addition to the section on theft. The Offence of Terrorist Act, which was so far not part of the IPC, has been introduced. So, to a huge extent, this has tried to bring in the regime of the UAPA within the IPC, but there is no express repeal of the UAPA. In fact, the provision of this act talks about giving powers to a police officer not below the rank of the superintendent of police to decide whether on commission of an offense, the accused person has to be booked under the IPC or under the UAPA, which logically leads to the fact that there will not be charging under both offenses simultaneously. So in terms of looking at a terrorist act, it's an act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, or economic security of India, with the intent to strike terror or likely to strike terror in people in any section in India or in any foreign country. I've taken a very small part of the act, the section. It's much longer in terms of providing the kind of illustrations which talk about, I mean, not illustrations, but subsections in the section themselves, which talk about the modes of how terrorist activities may be carried on. I'll just read out a few. So 113(1) small a talks about using bomb, dynamite, other explosive substances, which causes death, which causes loss of damage to property, disruption of supplies or services, damage to monetary stability of India, damage or destruction to any property in India or in a foreign country. So this is the destruction and damage of property looked at here is different from the UAPA, which only talks about government property, whereas IPC broadens the scope to include any public or private property. Then there is detains, kidnaps, abducts any person and threatening to kill or injure such person, or does any other act in order to compel the government of India. So these are some of the, in ways in which the definition of terrorist activities have been expanded. The original draft also included an explanation which defined who is a terrorist and what is a terrorist organization. But there was a lot of critique on that, and the standing committee also had made recommendations to remove that. And in the current form of the act, those explanations have been removed. So in terms of the punishment for activities under Section 113, if the terrorist act leads to death of a person, then the punishment for such offense would be death or life imprisonment with fine. If the terrorist activity does not lead to death of a person, then the punishment would be 5 years, from 5 years up to life imprisonment plus fine. If a person is involved in abetting, aiding, conspiring of any of the terrorist activities, but not directly committing it, they will be punishable.
You have to be updated, Nancy.
They will be punished with 5 years to life plus fine. There's an offense of organizing camps, training, recruiting for terrorist activities, the punishment for which again is between 5 years to life imprisonment and fine. For just being a member of the terrorist organization, the punishment is up to life imprisonment plus fine. There's no minimum mandatory here. Harboring or concealing a person who is involved in a terrorist activity attracts 3 years punishment to life with fine. And if there is possessing property from terrorist act, it is up to life imprisonment plus fine. The rider on possessing property says that the person should intentionally and knowingly possess such property. So any innocent possession of property which has been created or bought through terrorist activities or acquired through terrorist activities will not attract this section. So we come to this section on acts endangering sovereignty, unity and integrity of India, which is very, very similar to the original section on sedition. In fact, broader. And it's interesting how the government's claim in the speech while introducing the bills was that the act of sedition, the offense of sedition has been done away with because it is colonial. However, it comes back in a form which is, if anything, broader and more vague, which gives place for misuse of the act. So the section says it criminalizes acts endangering sovereignty, unity, and integrity of India. The punishment is imprisonment for life or 7 years. The wording in itself is not very clear, but it seems to be alternate punishments instead of saying from 7 years to life. While this is not labeled sedition, it retains the spirit of 124A and covers wider range of acts, which also create implications for constitutionality, the way the words are vague. It also includes new means of committing offense, more specifically electronic communication and financial mean. And the only protection that has come in this section is that the wording, the language of the section says purposely or knowingly. So it brings in that protection of mens rea requirement for committing such an act. So these were some of the changes in the IPC that, the Bharatiya Nyaya Sanhita that I looked at. There is obviously a very, very long list of sections where there has been enhancement of punishment. And for just in terms of interest of time, I'm not looking at all those. If anybody wants to get in touch to discuss or look at that, we'll be happy to do that. Most bare acts of the acts actually have a list of sections which are enhancing punishments, which are enhancing fines, and also sections which have been repealed or added. So I'll now look at the provisions in the Evidence Act, which have changed by the Bharatiya Sakshya Adhiniyam. And the most relevant one in that is, so there's only one significant change, which is the scheme on evidentiary nature and admissibility of electronic evidence. Unfortunately, there are no changes to Section 27 of the Indian Evidence Act, which when one talks about the colonial regime, Section 27 of the Indian Evidence Act basically makes confession to police admissible in ways where such confession leads to other recovery. And that is one of the section which sort of drives a lot of custodial torture and the way in which investigations are loaded with physical torture. And when one talks about removal of colonial remnants in the criminal law, this is one of the first thing that comes to mind. Unfortunately, this has not been addressed in the act. So looking at the electronic evidence, the definition of the word document in Section 2, which replaces Section 3 of the Indian Evidence Act, defines documents to also now include electronic or digital records. So earlier, this term was not included in the Indian Evidence Act. And now any document within the definition of the Bharatiya Sakshya Adhiniyam will include electronic or digital record. Similarly, references to electronic records which were added by amendment in the Indian Evidence Act, they are deleted from the sections which are retained almost verbatim from the Indian Evidence Act. So there's a newly introduced section 61, which talks about electronic or digital record, and it prescribes that admissibility of electronic records cannot be denied on the basis of their nature as electronic records. So this is bringing in a more emphatic, a more assertive provision to to sort of bring electronic records at par with other documentary evidence. But the section puts a requirement of the admissibility and enforceability of the document being subject to the provisions of section 63, which talks about how the document needs to be proved and the requirement for certification of electronic records. So under section 63, which is again retained from section 65B of the Indian Evidence Act, it talks about the admissibility of electronic records, and the scope of how electronic records are to be understood has been expanded to include output from any communication device, which means very clearly now mobile phones and other tablets, all those clearly come within they were already within the ambit of the Indian Evidence Act, but this has been put out in so many words and included here. And it adds that information in electronic record may be stored, recorded, or copied in any electronic form within this provision. Output of the records may be produced by computers, communication devices, which are working standalone, or in any system or network, including those managed by an intermediary. And the use of the word intermediary, as it is understood, will include telecom service providers, social media services, etc. So obtaining electronic records, the sources of obtaining electronic records as evidence, the output sources have been broadened here. One welcome change is, and something that was not there in the old act, was that it did not specify the stage at which certificate for authenticity of such electronic record must be produced. But the Indian Evidence Act, the Bharatiya Sakshya Adhiniyam within section 63 mandates that it has to be submitted along with the electronic record for admission. So it sort of supports the authenticity and also reduces chances of tampering of the evidence. The Act also provides within the schedule a format for there's a two-part format for how the certificate has to be given. And it will have to be signed by a person in charge of the computer or the communication device and an expert, whichever is appropriate. So there are different formats prescribed. So one part is the person who is extracting the information, who is in charge of maintaining that computer system or the network, or let's say if you're looking at an intermediary, the service provider, they can produce copies of the original electronic record and certify that it is in the correct condition, it hasn't been tampered, and it's the correct copy. As well as there can be experts who can certify it to say that the sources seem to be legitimate. So these are the changes within the Indian Evidence Act. Yeah, that brings me to my end of my presentation. I think we'll take questions at the end.
Thank you, Medha, for your insightful presentations. There are some questions that have come up in the chat, and we have taken note of them. And after Monica's presentation, maybe Medha and Monica can take them up. Over to you.
Thank you. Yeah, so today my presentation is going to be shorter because we covered a lot of ground yesterday. So I'll start with, mainly here I'm looking at arrest and detention and some of the rights of the accused, both in terms of, compromising the rights as well as expanding that, and also bail, the changes made in bail law, and then how does it impact JJ Act and children in conflict with law. So here, as it is, the CRPC had given, yeah, okay. So Agatha will do that after we finish presenting. Yeah, and sorry. So we all know that, that private arrest could be made even prior to BNNS. The thing is that under the current CRPC, in case of a private arrest, so if I've seen someone commit an offense, I can arrest that person privately and hand over the person to the police. But here there's been a time limit put that within 6 hours, the person has to be handed over. Earlier, it was like without delay, and there was no time limit, but now it's been put that within six hours. And we all know that under DK Basu's case, certain rights have been given at the time of arrest, such as medical examination and informing the family about the arrest. Under DK Basu and the consequent amendment, it is family or friend, but now it's been expanded to include any person whom the accused names can be informed of the arrest. In case of women, it is mandatory, but having said that, it was anyway supposed to be mandatory because violation of DK Basu's guidelines are supposed to amount to contempt of court. And it's also in the CRPC. And also prior to DK Basu, Sheila Barse's case had also said that if a woman is arrested, then, there were guidelines issued as to what should be done. That now has extended to any person being informed. So again, any police officer, as against only a, sub-inspector and above, can seek medical examination of an arrestee, including collection of samples. So that, now any police officer can ask for a medical examination, and at the time of medical examination, any samples can be collected. We know that, 41A of the CRPC had restricted the right to arrest in cases of offenses punishable with under 7 years. That continues, but there is a new proviso which says that in case of offenses punishable with less than 7 years, generally arrest should not be made. Only if the accused is infirm or above the age of 60, it can be only made with the permission of the superintendent of police or above. So now there is a restriction as to arrest of people who are arrested in minor offenses, but the caveat is that those who are above 60 or are infirm. The information about arrests had to be maintained and sent to the magistrate, and the magistrate had to keep it on record. But now, and this has become a bit of a controversial provision that there is a designated police officer who has to maintain record of all arrests and arrested persons. And this information has to be displayed in all police stations and headquarters. So there's this kind of a centralization of the database of those who are arrested. I don't see it as a completely negative issue because in our experience, despite DK Basu's judgment and the provision in CRPC, many of the people who are arrested are really not informed about their family is not informed, or nobody is informed about their arrest. And many of them, actually, their phones are immediately seized on arrest. So at least in FTF, what we are seeing is large number of people, their families have not been informed of their arrest. And what we've also found is that they don't even have the contact details of their family because their phones are in the custody of the police. So at least for the family, if they're trying to trace the person, this could be a way in which the person could be traced. Of course, it has the flip side of, human rights violation, and you're only arrested, but already there's a centralized database being created of those who have been arrested. So that of course is an issue. Um, uh, but it also will help in figuring out if somebody's been illegally detained, because if your name is not there anywhere and you know that the person has been picked up by the police, for example, if somebody's been picked up by the police at home, then for to make a case out or file a writ of habeas corpus and all that will get you can't create a backdated record of arrest in those cases. So to that extent, it is also, it's like a, it could be used either way. It could be interpreted either way. The other issue is also, of course, handcuffing has been brought in despite, does any of this apply to children in conflict with the law? So the thing is that generally, if a child is being arrested, of course, the family has to be informed. And medical examination also can be called for, but 3 years or less, is not going to apply because it's 60 and infirm, unless the child is somebody with a disability. But a record of the arrest will be maintained. One has to look at how does it impact the provisions of JJ Act, which talk about no records being maintained. Because how do you destroy these records subsequently is an issue that one will have to actually look at, because the JJ Act specifically says that there should be no records post the arrest, and there should be no criminal record should not be looked at of a child in conflict with the law. But otherwise, in terms of arrest, all these sections will apply, according to me. Of course, handcuffing has been brought back of habitual repeat offenders who have escaped from custody and have committed listed. So there's a list of offenses: bodily, social, or economic offenses, which includes POXO and sexual assault. So handcuffing has been brought in for, though not for supposedly for everyone, but in serious offenses, definitely handcuffing has been permitted. One has to look at, because there are at least two Supreme Court judgments which have very categorically said that one second. I don't think it is also, I don't think it is, Swagata, I don't think it is only pertinent in cases of children who are treated as adults and later found to be a child. But it can also be that I'm arresting a child, and then before I hand over the child to the JJB, and that would be mean that the process would include sending the child for medical examination. Because I personally have seen children being handcuffed, and though there is a ban on corporal punishment, etc., but I actually argued the case before a JJB on the ground of the Supreme Court ruling, saying that it's unconstitutional. So that was how it had happened with me. But according to me, there's no bar which says that these provisions will not apply to the child who's been arrested. The only thing is that you don't keep the child in the police station. You immediately take the child to the JJB, and then the JJB sends the child to an observation home or a place of safety, or releases the child on bail. So according to me, yeah. Yeah, then of course there is a this thing of in the bail provisions, there is a change, and these changes from 1 to 4 are really in terms of what we know as the 436A provisions. That is, if you have spent half your term, half the maximum sentence under the law, in custody, then you're entitled to automatic bail. But of course, a judge has the discretion to reject your bail. But generally, you get entitled. You have a right to bail unless, of course, the discretion is still given to the judge to reject your bail application for reasons to be recorded. But this 436A is not applicable to cases which are punishable with death. Its ban has been extended to, or inapplicability has been extended to cases which are punishable with life imprisonment and where a person has been charged with multiple offenses. So in those cases, the person cannot get the benefit of this provision of getting released on bail. First-time offenders who are not convicted will get bail upon undergoing 1/3 of the term. The superintendent, so under the UTRC, there is the Supreme Court ruling yeah, sorry. So the Supreme Court ruling in, inhuman conditions in 1382 jails, which directed the setting up of under trial review committee to look into how many people are in jail who have completed, there are now 14 categories, 14 or 16 categories under which a person can be released. So to see those who are eligible for release, and then the UTRC forwards it, and the DLSS secretary forwards it to the concerned courts, and then the judges release the person. Now instead of the UTRC giving UTRC a kind of a legal status, the onus has been put on the superintendent of the jail, of the prison, to forward list of those eligible for release for completion of specified detention period to the concerned court. There are many issues with this, because many of the superintendents really don't have full information. Like, for example, to find out whether it's a bailable offense, or whether the person so there are categories such as even the entire sections are not very clearly, as per our, experience. The prison records don't really have accurate information of either the case numbers, the court number, the courts, or even the, or the sections which are applied in many cases. So there is going to be so there is going to be an issue, but it's a positive step, because at least some of the people, if the onus is on the superintendent, at least some of the people are likely to make it in the list, and there will be a process which will permit release in that sense. So anticipatory bail, there had been in, I think, 2009, there had been major amendments which gave which mandated that the public prosecutor has to be heard before the final order of release on anticipatory bail is granted, which had said that the accused has to remain present. I'm sorry, I've written essence, but it should be presence. In which the accused has to remain present in the court when the final order is being passed, so that in case it is rejected, he can be taken into custody immediately. And there were grounds for arrest, so that has been deleted. But we all know that for cases of child rape, anticipatory bail was, the right to anticipatory bail was not there for accused, but now it has been extended to all cases of aggravated rape. So it's not just a child rape, but all cases of aggravated rape, the accused are not entitled to anticipatory bail. And this, we know that there are so many contradictory judgments on anticipatory bail, even for children in conflict with law. So that is something that, one will have to, and the fact that so many children are in for cases of sexual assault, one will have to actually look at how it's going to impact their rights. Then there's a major change which has come about with regards to proclaimed offenders. So all offences punishable with 10 years or more. So earlier there was so you could issue so there is something called a proclamation. So we have summons and then we have warrant. And then again in that we have bailable warrant and non-bailable warrant in case a person is accused, is released on bail and is not coming to court, is not attending the matter. Then there is a third stage that even after an NBW, if the person does not appear, then a proclamation can be issued and there is a procedure for that. So that remains. And once a proclamation has been issued and the person hasn't come, certain offences, there was a list of offences where the person was declared a proclaimed offender and the trial could be held in the absence, but in the earlier law, there was no, you couldn't pass the judgment. But now the provision with regards to trial of proclaimed offenders in their absence has extended to all offences punishable with 10 years or more. Even the judgment can be delivered, in the absence of the accused. And then all the property of the proclaimed offender in India or outside India can be seized, while earlier it could only be if the court has reasonable grounds to believe that the property is derived from an offence. So this allows for forfeiture of property to the central government. Yeah. Sorry, I'm trying to, yeah. Yes. Yeah. Yeah, some more, provisions which impact the accused are, as I said, any person, the court can ask any person to give samples or specimens without being arrested. So at the time of trial, if the court feels that somebody should be, witness samples should be taken or, specimen signature should be taken, that can be the person, the court can ask the person to give it. So, this whole right against self-incrimination has been compromised. The other is that audiovisual presence of the accused is allowed either during the dates or during the trial and during the pronouncement of the judgment. So it can be that your presence need not be in person, it can be virtual at any stage of the trial. Then there is a provision for timelines for mercy petitions. So earlier there was no timeline, and now this whole section on mercy petitions has been brought in. As we know that in death penalty cases, mercy petitions can be filed to the governor and the president. So now there's a timeline given for filing of these mercy petitions. So within 30 days of being informed of the fact that you've been awarded death penalty, your appeal has been dismissed, your final appeal has been dismissed, you have to file your mercy petition to the governor. And within 60 days from the rejection of your mercy petition by the governor, you have to file the petition to the president. And there's no appeal against the president's decision, and the decision has to be conveyed to the accused or to the convict within 72 hours. The other provision which has come in is with, the major changes are commutation of sentences. So we all know that, the state has powers to commute or, replace a sentence, a more serious punishment granted by the court with a less serious punishment. So the power of the state was always there to commute death to life, which continues. But there are other changes which have come in. So life imprisonment. So earlier it was not just death to life, it was death to any other punishment. So now it has been restricted that if you've been given the death penalty, then it can be only to life imprisonment, whereas earlier you could get a reduced sentence. If it is life imprisonment, then not less than 7 years. Earlier, it was not less than 14 years. In keeping with the the provision of no remission lower than 14 years. So now it's become 7 years. And this provision of if it is between 7 to 10 years and not less than 3 years, this provision was not there. This has been included, that if you have a punishment of up to 10 years, it can be commuted to to up to 3 years. And rigorous punishment can be commuted to simple imprisonment. Earlier, it was either simple or fine. But now, it will be only simple punishment. It will be simple imprisonment. It won't be all fine. And sentence of 3 years for fine. This is a new section which has new provision which has come in. And then, of course, as I mentioned yesterday, that police custody. Okay. See, the thing is that Nimisha's question about the proclaimed offenders and whether where it'll have to be in cases which are punishable with 10 years or more. Only in those cases can the proclaimed offender, and then after proclamation is issued, so the whole process is to be gone into before it is done. It is not a mandated thing, but that option is always there. So the option will be there with the courts to actually hold the trial like that. But according to me, for JJBs, they should not do it, especially because anyway, if there is a period which is elapsed and now the person is no longer a child, even if you convict the person, you anyway are not going to be able to. Suppose I was 15 when I committed an offense which is a serious offense, which is a heinous offense. Then anyway, after I turn 18, you can only send me to the special home up to 21. So unless I am between 16 to 18, in those cases, and if it is not tried by the JJB, in case it is being tried by the children's court, in those cases, this provision will be can be used. Yeah. And then, of course, as one said that, police custody now means custody in any police station and judicial custody. But of course, this will not apply to children because they can't be kept in either of the two places. Yeah, so Juvenile Justice Act, it has a non-obstante clause that notwithstanding anything, and BNNS says very clearly that special law shall prevail. So therefore, Juvenile Justice Act will prevail. And of course, the principles including presumption of innocence, fresh start and diversion will continue to operate. And therefore, according to me, the more what was said that proclamation should not be issued and many of the provisions should not be applied should actually not be applicable to cases of children in conflict with the law. The bar on keeping children in conflict with the law in a police lockup or in jail continues. Provision with regards to a broad definition of place of safety, will continue. And the bar on keeping till you turn 21, even if you're tried as an adult, will continue. CCLs cannot be sentenced to death or life imprisonment without release. That continues. No chapter case against a child in conflict with the law continues. No joint proceeding with adult continues. The trial of heinous offences, of course, continues. The BNNS procedure has to be followed in cases of appeals or revisions, whereas the JJ Act provision will apply to all inquiries relating to children. The ambiguity regarding grant of anticipatory bail to JJ to children in conflict with the law, where, like, for example, we have judgments where, under Atrocities Act or under sexual offences where different high courts have taken different views. So that actually should have been resolved, because there is no provision for anticipatory bail in JJ Act. Therefore, there is this confusion, and that will continue till it is finally resolved by the Supreme Court. So that is. Yeah, there have been many questions.
Yeah, thank you for your presentation, Monica. We'll open the floor for questions. You can either type them and raise your hand to speak. Maybe we can begin with the questions already in the chat. There is a question from Nisha, which says, I can imagine all sorts of confusion because of this. If all arrests is to be displayed, would that mean that the CICL accused of heinous offences against whom FIRs have been filed, their confidentiality will be violated?
See, I don't know whether the police are actually going to think that, oh, there's a child in conflict with the law. Like, as rightly said, many of the children who are actually arrested, especially 16, 17 years old, they are arrested. Their age is always shown as higher, and they are arrested and they're treated as adults till, one actually brings evidence to show that they are, or they have uncontroverted evidence at the time of arrest to show that they are actually children. In those cases, I don't know whether the police, when they're given the training, are actually going to be told that this does not apply to, children in conflict with the law, and that that information.
They refuse to believe you, Monica. They just, like that's already that is already the case. They refuse to believe you. You are like, look at this. It's written in the act, but they will still not believe you. Now it's going to become worse.
Yeah.
And also, one thing that you mentioned yesterday about that provision to sort of send that daily diary every 15 days to
in
the
non-cognizable offences. That
yeah,
is
so for children in conflict with law, the JJ provision is that you don't file an FIR, you make a DD entry, right? So instead
if
of
it is an adult, if I'm arrested along with an adult, there will be an FIR, no, Nimisha?
No, there will be an FIR. But if there is no FIR, there is a DD entry. That is the provision.
Then
for
that
most,
has to be sent. Oh, that
yeah. So that DD entry is also sent. I mean, I understand it's not like that record is going to be published, but it is a like it's sort of going out of the police station and it's being sent, because the provision is that if you are, when you're not filing an FIR for CICL up till the age of 16 and 16 to 18 for petty and serious offences, you are not supposed to file an FIR, you're supposed to make a DD entry. So if all of that record of DD entries is also going as that sort of like regular sort of update. So,
but
like if there is
FIRs, I've seen FIRs of even children, where, like, especially in sexual offences and all, children in conflict with law, one sees FIRs, it's not as if
yeah, in fact, you will be hard put to find that DD entry actually. We have done that. We have gone to police stations and we have not found any DD entries. But that's what I'm saying, that, it becomes all the more difficult in terms of capacity building efforts. The police already were finding it hard to believe. So yeah, just that. And just a very quick follow up on that
collateral, impact on, for the worse on children in conflict with the law. That definitely is going to happen, because how do you even distinguish? Because the manner of investigation is still going to be the same, and if you're going to record statements and things like that, then that is again, even the police don't know which statements are supposed to be recorded and which are not to be recorded. Yesterday, I was talking to my friend who's a public prosecutor, and she was saying that now police are saying that, like, they are under the impression everything has to be recorded, so there's still a lack of clarity about what is going to be the And I don't know how the courts are also going to interpret, I mean, none of us know that.
There was a question from Swagata saying, hope can also share your thoughts on the application of BSA and BNSS to cases that were registered before 1st July and are pending.
Okay, I'll go first. So see, BNS, to an extent, will not apply because, so you have this non-retrospective application. But according to me, it can apply if the new provision favors the accused. So as long as you're not met with a penalty which is higher than what the previous but it's more applicable to substantive law or substantive criminal law and not really the procedural law. So whether when the investigation is being carried out, how is the police, of course, the FIR will be in the sections which were there prior to at the time of commission of offence. So according to me, the IPC provisions will apply, or whichever law was there will apply. You can't have, say, for example, a retrospective application of, say, terrorist act or organized crime, which is not an offence on the day you've committed it. You can't have that. But when you're investigating, then according to me, they can, like, if they are if the FIR has been registered, say, on the 1st of July, then according to me, there is, scope for the interpretation that the investigation can go as per BNNS, even if the offense was committed prior to that. The only thing it can be challenged is, for example, if somebody is being handcuffed, then you can argue both constitutionality as well as the fact that this person is it is a retrospective application of which impinges my rights. So according to me, so there is going to be a lot of because if I'm a lawyer and I will definitely argue for what favors my client. So that ambiguity is going to be there. Yeah. Medha, you're on mute.
Yeah, so no, I agree with what you're saying. I think in terms of FIRs which have been lodged by 30th of June, the old provision of investigation will continue.
I think we lost
I think she kind of got dropped out by mistake. Yeah. What do you all feel? What is your reading, Swagata?
Yeah, my question was for the procedural, not the substantive. So I think I saw that Telangana has issued a notification clarifying what will apply. But in the absence of that, are we going to see every court and every state figure it out along the way? So that's the concern.
Unless the government start issuing notification, they'll have to do it sooner or later. They will have to do it. But it's also going to be very difficult for the police to have simultaneously carry out investigations in it. But for example, if statements of witnesses are already recorded, then you can't say that now, call the person again and now record it, do an audiovisual recording. You can't say that. So that.
There's a question from Din Bandhu, which is police custody to 15 days in parts during 60 or 90 days. Does it mean that no bail before 60 or 90 days, as police can ask for custody at point of time during?
So the provision actually says that, that the court has to look into the fact whether the person is on custody or is out on bail. Now, what does that mean? You know, because according to me, you'll have to apply for cancellation of bail and say you'll have to make a case out for cancellation of bail and further custody. You can't just say that, if the person is out on bail, you can't just say that I want police custody. You have to make a case out for both. But definitely in a bailable offence, one can't say that for 60 days the person has to be remain in custody because the police have the right to, because 60 days is the minimum time that the police has for, investigation of any case. So in a bailable offence also, they have 60 days time. Then the whole point of a bailable, so according to me, you'll have to apply for cancellation, make a case out for cancellation, and then make a case out for custody.
Medha is back. I think Medha, you were cut off when you were sharing your thoughts on the application of IC and BNNS.
Yeah, sorry, I lost internet. So no, what I was saying is everything up to 30th of June will be the procedurally would be under evidence in CRPC. And I think any investigation that gets initiated after the 1st of July is, I mean, as per logic, should follow the BNSS and the BSA.
There was a comment from Sneha, which was, my understanding is the territory of apprehension of minors will continue to be governed by JJ Act and the rules. Sneha, did you want to come in and talk about your comment?
Yes, it would be. I don't think there is any conflict with the JJ rules and the JJ Act here. I think only to the extent that there is applicability to children who've been charged with heinous offenses, that 16 to 18 category. That's where the BNSS will come in. Monica, is that correct?
And according to me, even at the time of investigation, for example, if you're asking the child to go for medical examination, etc., you can use these provisions. So if there's a test identification parade, for example, then the BNNS provisions, which says that it has to be in case the, where it has to be. So to a certain extent, there is an overlap. It's not, JJ Act is not a complete code in terms of telling you exactly how to investigate an offense. You know, it tells you about inquiries, how they're supposed to be conducted, and what kind of orders can be passed against these children and what has to happen. So it's more about the way in which you deal with the child whom you take into custody and what you're supposed to do with that, rather than about how you investigate an offense. Because just because I have a child doesn't mean you don't investigate. You can't just write an entry and then take me as an accused. You still have to investigate, get evidence against me. Finally, how I'm processed through the system is under the JJ Act, in the sense that I can still be held to have committed an offense after a trial, not before a trial. So, I mean, on paper, yeah.
There was a question from Shruti. Are there any provisions in BNS that require the accused to report?
So I actually, apart from that provision, there is no other provision. I did a check when I saw the question and Medha was doing the presentation. I did a quick check. Apart from that,
I also just wanted to clarify, actually, Swagata pointed out the persons acting in concert exception that I mentioned for section 117, which is mob lynching and grievous hurt. It was actually there only in the bill, and the act has done away with that. So the act actually reads uniformly for the way offense of murder and grievous hurt has to be looked at. So anyone acting in concert also for grievous hurt can be charged under 117(4).
There was a comment from Santosh saying, so far the Supreme Court's decision on the issue of handcuffs has not been respected. The prisoner is brought from the court lockup to the courthouse, handcuffed like an animal. Santosh, do you want to come in and elaborate?
yeah, but at least on paper we have, no, they can't do it. They're doing it, but I mean, we can still say it's unconstitutional, it's illegal. We can use those terms. One can still have a space to, say that this should not be done.
There is a question from Shruti. Are the newly introduced limits on extension of commutation of sentence in violation of child rights, if it becomes applicable also to CICLs who are tried and sentenced as an adult?
See, the thing is that if you're a CICL, then anyway, you can't be given death penalty and you can't be given a life imprisonment without release. In fact, the thing is that it's only for, if you look at it, a CICL who's tried as an adult is only for a heinous offense punishable beyond 7 years. So actually, I don't think it's going to adversely affect that child, because if you're given life imprisonment, you become eligible for release in 7 years instead of 14 years. And if you're punished between 7 to 10 years, then you're eligible for release within 3 years. So to that extent, it's going to actually not adversely affect a child, because even if I'm, say, arrested when I'm 16 and I'm convicted and I'm sent to a place of safety and I'm there for 3 years, and at 21, I can always ask for my, say that there's a scope for argument that I should not be, that the provision itself assists in release. Or if I'm sent to jail also, I can ask for an early release after that. So to that extent, I don't think, the commutation, because anyway, I can't be given death penalty or rest of my life.
We also have some former JJB members with us on call. So if any of you would like to reflect on these changes and your experience of how CICLs are dealt with by the police. I think some of them have dropped off. There was a question by Swagata earlier: would personal belief or other similar
Sorry,
grounds?
1 second. Gopika, I do see Ida here. Ida was a former JJB
Okay.
member. I think she's back. So Ida, if you want to share your thoughts. I see Asha also and Medhi both have done substantial work with children in conflict with the law. So if either of you would also like to come in and share your thoughts.
Hi. Hello, am I audible?
Yes, you're audible.
Yeah. So when one was talking about this provision of proclamation, and when you were talking about, identification parade, I thought these were not applicable in a juvenile justice system. And I think there are guidelines to state that this should not be applicable to the juvenile justice system. Hello?
Monica, you're on mute.
Sorry. See, according to me, I know, I mean, you would know better than me, but according to me, what my reading of the JJ Act is that there is no guideline as to how the investigation is supposed to be carried out. And
so if I'm not mistaken, I think there is a High Court judgment saying there will not be a proclamation. And in Maharashtra, we had brought out a SOP saying that there will not be a proclamation and there will not be identification parade that will happen when it comes to a child. Just thought I'll clarify that.
thank you.
I don't know, Ida, if you're here on the call and if you wanted to come in.
Hello. Yeah, sorry, I'm traveling, but when I went to, can you hear me?
Yeah. Yes, we can hear you.
So what I find is, see, only in IPC or this it is the titles and the punishment those have changed. So if I see this snatching, that is usually our children are involved. So that is gone to the petty offense below 3 years. These are advantages for us from the investigation from the other part of that. So JJ Act is not changed. So our problem was even earlier understanding the JJ Act from the beginning was very weak from the JJ board members or the judiciary members. They were never trying to understand the JJ Act itself. See, even now the procedure is, unless they understand the JJ Act, even this has changed, it doesn't going to have much changes because we do not know the JJ Act itself. Here the point is, do you know JJ Act? If you know the JJ Act, there are many things where we can apply for in addressing the children. But when we do not know the JJ Act, what we did all this time is we applied only IPC sections and CICL sections, and then we put them in the harsh situation. Even now, situation will not change unless you understand JJ Act. And here, I feel in some cases there are advantages, except those because there is mob lynching and all that. Usually, our children involved with the group. As a group, they attack, and as a group, they go and they do all these things. So those things they will have more problems. What they said, like there's a punishment now fixed below 5 years. That's the advantage I feel. Earlier, many JJ boards 02 treated as
Ida, I think we can't hear you clearly, so we only heard portions of what you shared. Thank you, Ida, for sharing your thoughts. Santosh, did you have something to share? I think you were saying something.
Can you hear me? Sorry, because I'm traveling.
The voice is a bit shaky and it's breaking, but we can hear parts of what you're sharing.
JJ is the same, not changed. So the problem was we never tried to understand the JJ itself. Like, you should not have FIR. Where everywhere is FIR. And we should not have child more than 7 years in OH, in the OH. So these are the provisions in the JJ Act which still applies. I don't think there's a change in JJ Act, but who will understand? I feel IPC, some sections are advantage for the JJ Act. I think we need to study a lot. I think I won't be able to say, but some of this it looks like it's advantage for children as far as we apply it. Now, one thing I do not know, always is a confusion about summary and summons that still we did not apply as well. And then there's one more thing, CRPC 243 or 246. it says it should not apply or should apply. Still, we do not know about that, not care about it. Judges are not care about that. Somebody can help in that, it would be ideal. Thank you so much. It's very my limited knowledge. I do not know with the new act so much, but I understand. Thank you.
We also have some lawyers here who represent children in conflict with the law. Would any of you like to share your reflections? I think Shivansh, you've unmuted. Did you want to share something? Are there any further questions or comments from anybody else on the call? Okay, in that case, if Medha and Monica, if you have any final comments that you'd like to share.
Yeah, just that, one thing that, we all know that there's been no change in the general exception chapter with regards to age. That also continues 7 years and then 7 to 12. That really could have been revisited, keeping in mind the fact that, child rights, there's been remarkable change in the way we understand child rights from 1860 to 2024. That is something that should have been actually, and given the fact that today most jurisdictions have 10 or 12 as of course, so probably instead of 7 to 12 could have been made, it could have just been made 12 years. That would have been a positive step, which unfortunately was not done.
Medha, any final comments you'd like to share? Medha, you're on mute.
So like I also mentioned in my presentation, there was obviously scope to have to do a lot more, which the legislators have not really taken into account. These changes are in no way decolonizing what was there, and is obviously there's going to be a lot more confusion about how the laws operate. What I personally am very, very scared of is the judges are so confused about the legal procedures anyways. How are we going to operate in a scenario where two different regimes will be working parallelly for a substantial amount of time? So I think, and that is something we'll only see how it is, only we'll see it play out in a bit, and maybe we need to do more such forums to just discuss how we are individually dealing with it at a programmatic level. Yeah, I think it's going to be a lot of learning from each other and trying to figure out how each one of us in our ways is dealing with what is coming our ways, finding strategies, looking at what can be collectively done to reduce the possible damage from this.
Thank you very much, Monica and Medha, for taking the time over these 2 days to break down these provisions in a manner that is simple and easy to understand, and also offering us a framework to understand them. I think in the coming days, a lot more questions will arrive when we start seeing the implications of the law, and we hope to turn to you in the future for clarifications and more discussion on this. I'd also like to thank the participants for joining us and engaging in this discussion. The recording of both this and the previous session will be uploaded on our YouTube channel, so you can stay tuned to it in the coming days. Thank you very much.
Thank you, everyone. Thank you for the
Thank you.
and the sharing. It was lovely.